So generally, these meal break waivers can be used if the employee is working no more than 6 hours. So less than 6 hours, they can waive the 30-minute meal break. Um, Again, we just had this case come out last week, confirming a lot of this that we've been telling clients. Generally, there is no requirement to have them in writing, but they should be. And also, there's a lot of confusion over on-duty meal period agreements with this waiver issue. So generally, on-duty meal breaks are very limited. And for example, we've had some opinions out of the labor commissioner saying in the restaurant setting, these on-duty meal period agreements are non-enforceable. So, but those are separate than these waivers. So we're just talking about this waiver for shifts less than 6 hours. We've had this new case that came out just last week, Bradsbery versus Vicar Operating. The key issue here was being challenged. The employer had this meal period waiver for shifts less than 6 hours. They had it as a blanket waiver. So the employees started as part of I think they had it as part of the new hire packet in this case. I can't remember if it was in the new hire packet or right as the employee joined. They would sign this blanket waiver saying, if I work less than 6 hours, I'm going to waive my 30-minute meal break for any shifts less than 6 hours. The plaintiffs challenged that, saying, look, you need to have an agreement each time. You can't have a blanket waiver. And the trial court affirmed what the employer was doing. And then here just last week, the appellate court also affirmed it as well. So basically saying that these written meal period waivers, the blankets are fine to have, but there are some warnings that the court came out with. But really, the actionable steps for employers here, we are still recommending that these agreements be in writing to show that they can be done prior and they can be blanket, but they need to be voluntary. And they need to have language in there that the employee can revoke the waiver at any time in writing, require that to be done in writing as well. And then you really need to train your managers and document how this is going to be handled. So you're tracking who's signing these waivers. And if you have employees that don't sign the waivers or revoke the waiver, it's being documented in the software. Hopefully it's software that's helping you manage this. So the employees that don't have these waivers, you're automatically calculating and scheduling them for the 30-minute meal break. Or if you're not scheduling them and don't get them that meal break before the end of the 5th hour, you're paying the premium pay as a penalty. And then, as I mentioned, just make sure it's voluntary, not coerced, that you're able to prove that there isn't some type. We see this argument come up a lot in litigation where the plaintiffs say, look, everybody signed that. I felt like I had to sign that. So if you've got a handful of employees that don't sign it, it's a good thing. Document that and show that nothing happened to those employees that revoked the waiver or refused to sign the waiver. Good stuff to have. And then obviously to maintain accurate records. And again, if you've got a number of employees over, I would say 50, 60 employees, this gets hard to track. You need to start tracking it, hopefully with some help from tech. And I like having that document the reason if they didn't take the meal break, why, and looking at that, because it helps defend cases in class action or PAGA cases that you can start pointing to these individualized issues that come up. So it's key to have that documented.